A lawyer in the public defender's office is accusing the state attorney's office of misconduct in the murder case of James Rhodes. Now, Rhodes is accused of shooting and killing Shelby Farah, who was working at a Metro PCS store back in 2013. His attorney says the state attorney's office broke the law when it allowed her brother Caleb to watch the surveillance video that captured her murder on camera. Now, Florida law states that only a surviving parent is allowed to view the video unless that parent gives permission for someone else to watch it. Shelby's mother says she did not give her son, Caleb, that permission. We spoke with public defender Matt Shirk about why he's now accusing the state attorney's office of breaking the law.
If what's alleged is happening, there is a Florida statute that makes that a third-degree felony. That's the way we read this law. I think others would agree with us. We find it very concerning, and that's why we brought it up in a letter to the assistant state attorney that was involved in it to see. All
right, so Caleb Farah testified that he was encouraged not to watch the video, but that he insisted. But public defenders say regardless of whether he wanted to watch the video, the state attorney's office should have never allowed him to do so. Joining us now this morning is local defense attorney Randy Reep. Good morning to you, Randy. Thanks for being here. Since this really focuses on the law, I want to read it in its entirety again so everyone is clear. Basically, it says, because the video shows the killing of a person, then only a surviving parent has authority to view this kind of video if there is no surviving spouse and no written designation from the parent authorizing anyone else to view it. Knowing that law, knowing what happened, no permission apparently was given. Is this cut and dry? Was it illegal? Did they break the law?
Regrettably, nothing in the law is cut and dry. I think what you'll find when we look at this is that when the brother, this Caleb, watched the video, it appears that the mother was there and was one of the people who encouraged him not to look at the video. Sometimes when things aren't written, but consent is given, we call that substantial compliance, and I don't know that you'll reach the level of a criminal act by not having a written compliance here.
Okay, what about, if a judge decides that there was some misconduct here? Is that an issue, at least for the prosecutor in this case, who's very, very well known, Bernie De La Rianda? He's been doing this for years. And extraordinarily well respected. I think there could be some admonishment. But what are you going to do? You're not going to dismiss the case against the defendant, obviously. There'll be potentially some scolding if it does appear that there was misconduct. Again, there was probably 4 or 5 people in the room, none of it being me or anyone else who probably in this position that can comment on it. But I think you'll find that no matter how it happens, having that brought to the attention of the court was very, very important. And I think you'll see some interesting fallout from it, but nothing relative to the case of Mr. Rhodes. And I just want to clarify something that I just said also. When I say that Bernie De La Rianda has been doing this for years, not this kind of in terms of, allegations of misconduct, but has been assistant state attorney for many years. So why do you think this kind of law was created in the first place then? I mean, I've been covering the courts for 8-10 years and I've never heard of it. Well,
it's actually really clearly spelled out in the comments of the legislator, and frankly, it's to preserve the dignity and memory of the deceased. A murder is a very unique crime, as you can understand. And if you can think, it's protecting the dignity of the surviving family. If you'll recognize, the law says the spouse has the first approval authority to never allow that to be given, and then it's the surviving parent. And you can imagine that these scenes are very graphic and very disturbing. It's not the memory families want left of their loved one who was in fact murdered. So there is kind of a deeper issue here, and I want to back up for those of our viewers who have not been following this case as closely as we have. I mean, all along, Shelby Farah's mother, this 20-year-old who was killed, basically this video apparently shows her handing over money, and even though she complied, she was shot 4 times anyway. Her mother has always said that she does not want the death penalty in this case because of the heinousness of the crime. The prosecution has always said, hey, this is an example of a case that needs the death penalty. There's a back and forth here. I mean, her mother has come out and said, I do not want this. Why does it matter legally in the courtroom when it comes to this case if her son Caleb has an opinion about the death penalty, if he's in favor of it or not? What does that matter? There are 2 big important points. One is we have to understand that the community is the victim of every crime. We have victims, but the community is the overall victim. That's what the state attorney would tell you. Angela Corey's office is protecting the community, okay? Now, when we get to the mitigation phase, and I know you've talked about this a lot on the new death penalty law, the victim's impact statement, the impact on the lives of the survivors here will matter to that jury when they come to a vote, which is going to be required to be 10-2. So not having surviving victims that are pro this defendant being put to death, it will be very difficult for the jury to find that this is somebody who should be put to death. So the state is looking long ball here and looking at the sentencing phase of the case.
Local defense attorney Randy Reed, thank you very much for your insight this morning. Do appreciate it. We also want to point out that the letter that accuses the state attorney's office of misconduct was addressed to the prosecutor in the case, Bernie De La Rianda. We did call his office. He says he is in the process of filing a response to the letter and that, quote, further comment will be made in the appropriate venue, the courtroom, end quote.